नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Looking at president appointment, etc., etc. Okay. So let me continue with our discussion of the executive. What we saw in yesterday's class was the appointment of a president, how a president is elected, what happens during a presidential election if there's a dispute. Shauvinik, just turn off your camera. It's just taking up bandwidth of other students. Many of our students are not in good connection areas, and I want the bandwidth to be reduced. Otherwise, too many students, camera load is too heavy for people. Right. Now today, let me just continue with where we were. I am going to go back to Article 53.1. Just please open your constitution and let's look at 53.1. Okay. Now 53.1 tells us that the executive power shall be vested in the president and shall be exercised by him either directly or through officers subordinate to him in accordance with the Constitution. Okay. Now just turn to Article 77, which is linked to Article 53. The decision, because 53 says either it will be exercised by him directly or through officers subordinate to him in accordance with the provisions of this Constitution. Now look at Article 77. Article 77 tells us about the rules of government business. Okay? And this tells us that all executive action of the government of India shall be expressed to be taken in the name of the president. But it still doesn't tell us whether it's being done directly or by officers subordinate. But everything will be in the name of the President of India. Now, yesterday, when I was talking to you about Article 361 and the immunity, I told you that limited immunity is given for actions taken by the President by virtue of his office. Yet, normal executive orders, for example, there's an order for demolition, let us say, of slums here in Delhi. It may be taken in the name of the LG or the President. Does it mean that this is immunized by 361? No. 361 gives only for those actions against the President personally and directly. Now look at Order 2, Subclause 2. Orders and other instruments made. If complete immunity was given for all executive action, believe me, we would never be able to file a writ petition challenging any executive action because the immunity power would be overbroad. As a result, 361 is focused on those proceedings where in his personal capacity or in the criminal capacity, of course, they cannot be done. But those actions which are to be defended by the Council of Ministers will be subject to judicial scrutiny. Okay, but not under 361 where he is doing personally. Even there has been a reduction. I told you, even imposition of President's rule now is subject to judicial review. This is what the Supreme Court has expanded. So there is a diminution of that Article 361. Next, look at 377 Clause 2. Orders and other instruments made and executed in the name of the President shall be authenticated in such manner as may be specified in the rules. Okay. And made by the President, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the President. There's complete ouster of any judicial scrutiny about suppose, for example, appointment of a High Court judge. The warrant is issued by the President. You cannot file a petition saying that this is not the warrant and seal of the President. That is out of. Now come to subclause 3. The president shall make rules for more convenient transaction of business. And so these are the rules of business that are made. Portfolios of the different ministries. If we are talking about governor, then in the states we don't have ministries, we have departments. Okay, there's just a nomenclature difference, ministries and departments, that is there. So therefore, under 53, either president directly or through officers subordinate, these officers who are subordinate, all action will be done in the name of the president. That's Article 77 for you. And then let me just conclude this small point with Article 78. The duty of the Prime Minister, it shall be the duty of the Prime Minister to communicate to the President all decisions of the Council of Ministers relating to the administration of affairs, furnish such information relating to the administration to the President as the President may call for, and submit any matter which has been discussed by the Council of Ministers. We don't use the word cabinet here. We use the word Council of Ministers because that's the phrase that is used in 74 and 75. Okay? Article 74 and 75. So the need to communicate, because while under Article 53, all executive power is vested in the president, there are enough judgments to tell us that the president is the constitutional head. And as the constitutional head, the day-to-day executive work is actually carried out by the government, but the president is the constitutional head and in whom the executive power is vested. So, along with Article 77, which tells us that all business done by officers subordinate, that clarifies 53 here in 77. The other article that I'd just like us to very quickly look at so that we have the complete picture of the manner in which there is the executive power is distributed or utilized is Article 299. So I'm looking at 53, I'm looking at 77, I'm looking at 78, and finally I'm now looking at 299. Okay, now look at 299, it's very clear. All contracts, the power to have property and to have contracts is there in Article 298. Okay, then trade, commerce, etc. And property rights are there. Escheat, for example, is there in 96. 296, you looked at escheat last year when you did Hindu Succession Act. Things, property, where there is no heir goes to the state. So the Union of India has the right to hold property, has the right to transact on that property, 296, 297, has also the power to engage in trade and business. Very important as we will come when we come to fundamental rights, that once you move from a laissez-faire state to a social welfare state, there are many business entities which the government has run. Of course, now is the great period of what is the phrase to use? We are disinvesting. That's right. That's the word I wanted. We are disinvesting, but in the heyday of planned economy, you know that in the first 30, 40 years, when the commanding heights were purely under the government control, when you look at the first 5-year plan, Mahalnogar's second 5-year plan, more and more public sector, which were under the control of the government, were engaging in trade. And then you have some direct government departments like the railways, not under any public sector enterprise, but actual departmental undertakings done directly by a government ministry, also engaged in trade and commerce activities. Now, 299 tells us all contracts made in the exercise of executive power, both property dealing, commercial dealing, all these contracts shall be expressed in the name of the president or the governor, as the case may be. I'm just using the word president, but whatever I say holds true for the governor. Okay. So, 53, which has vested the executive power, can be done by people subordinate to 77. And all contracts, all commercial dealings will be done in the name of the president. These commercial dealings, all these subordinate activities of appointments and orders can be subject to judicial review. The power of the court as a constitutional court, Supreme Court and the High Court, to challenge any action of the government which exceeds its executive power or which is exercised nullified or due to non-application of brain or of mind, all those petitions can be filed notwithstanding Article 361. That article immunizes the president personally from having cases filed against him in a personal capacity. This does not mean that you cannot file against the Union of India. You cannot file against President of India. So please appreciate the limited nature of what 361 provides for. It does not mean that actions of the executive are outside the judicial review of the courts. No. Actions of the Union of India shall be done. Okay, so that's the relationship. Now, this executive power is vested in the president. I go back to what I began when we started this session. What exactly is meant by the executive power? So let me first take Ram Javaya's case and then go again back to 73. It's so important. I want to now deal with it in a more detailed way that I just touched on preliminarily. Ram Javaya, which I sincerely hope all of you have read. Okay, if time had permitted, I would take up each case and have somebody tell me the facts and tell me the contentions, and then we would have discussion. Unfortunately, this is such a vast course. If I started doing that, I would need 50 days for the 50 cases, and then I don't think that would leave me with very much other than teaching time. But I hope you remember the Ram Javaya case where Punjab government, apart from permitting private publishers to print textbooks which could be selected by government and private schools as prescribed textbooks, they were all there in the list of prescribed textbooks. The government thought, why should we also not become book publishers? So they also jumped in and started, publishing the books. I took up the case of damnum sine injuria, that just because there is a new player in the marketplace of textbooks, does that take away the fundamental right of freedom of trade, business and occupation, which is provided to every citizen under Article 19(1)(g)? And that in fact was the first argument here. That's right, Vartika. No, it doesn't mean that, because you are permitted to be a player, but you are not permitted to grab the entire market. So the freedom is only a freedom to be a player. There is no duty cast upon the state that you are ensured your market access. You are only ensured market entry. You are not assured of a market share. So in terms of the language of competition or antitrust law, you will appreciate the distinction between having market entry or market access and ensuring of a market share. So where you were earlier the only person, Anho mein Kana Raja, you were the only book publisher, ab 10 aur aa gaye, aap kuch nahi kar sakte. Aapka profit margin kam ho sakta hai. You can suffer damage, but there's no legal injury caused to you. So that argument gets taken care of. We did this in the previous class. Now the court says, should you be in the business of, second argument of Ram Javaya Kapoor was, why on earth are you publishing textbooks? Go defend our borders, print rupees, hold foreign relations. आप इसके बीच में क्यों आ गए आप हमारे बीच? The answer to that, the court tells us, is Article 298. Please look at 298. Power to carry on, the executive power of the union and of each state. Please look at 298. 298. What does it say? The business side of the government is part of the executive power. If I can make a tangential comment, business is also government. It's no dirty word. It's not a dirty word to do business. So what does the court say? The executive, not the court, the constitution in 298, the executive power of the union and of each state shall extend to the carrying on of any trade or business. Okay? So, It's not only a laissez-faire. What are the functions of a modern state? It's not the old-fashioned laissez-faire. You know what I mean by laissez-faire, right? It's not just the old night watchman laissez-faire state. You enter into all trade and business activities. So, ergo, you have all our public sector enterprises, which are running on principles of generating revenue, and to the acquisition, holding, and disposal of property. So the court says that Ramjawai Kapoor's contention is not correct because it's a constitutional power given to the government of the state to carry on business. And so they are fully within their rights to print these textbooks. Is there a legislation? Should there be a prior legislation before you exercise the executive power? To my mind, this was in fact the most powerful argument that Mr. Ramjawai Kapoor had put up. And what does the court say to that? That executive power is coextensive with legislative power. That is what Article 73 tells us. But it is not a condition precedent that before you exercise executive power, that there must be a law in place. If that had been the case, then executive power will become dependent on legislative power. But our doctrine of separation of powers places judicial, legislative, executive all at the same level. One is not exercised through the medium of the other. There are certain times when legislation is necessary. For example, if government wants money, it has to get it from an appropriation act, because our constitution clearly says that money cannot be taken from the consolidated fund without there being a law for the purpose. Or you are free to enter into any contract, but if that contract is going to curb somebody's fundamental rights, then you need to have a legislation authorizing you to thereby curb or reduce any fundamental right of a person. So some contracts may have the effect of curbing some rights, restricting some rights, in which case this can only be done by a law. But please note, as a general proposition, that executive power needs as a precondition the existence of a legislation is not correct. Which means that the true meaning of Article 73, subclause 1, subclause A, that the extent of executive power is over all those areas over which Parliament or the state legislature, as the case may be, has the power to legislate, is only delineating to you an area or an extent over which executive power depends. But it doesn't make it dependent, therefore, on the legislature, except for those few cases that I was pointing out to you and which are explained also in the judgment. So then, is there a positive definition of executive power? And two very important points. So though Ramjawai Kapoor is an old judgment, it is still what we call the locus classicus on executive power. The first point the court says is that executive power is not capable of exact definition. It is in fact a residuary power after you pull out the legislative power and the judicial power. And what remains, which can be a little ragtag, little residue, would all become the executive power. That is, all governmental powers except those that are legislative and judicial in nature is executive power. So it can involve very many things. And if you look at your judgment, there is one small paragraph that is so important, but I would like to read it out to you. I'm looking at paragraph 12, and then I look at paragraph 13. I'll first read out paragraph 12. It may not be possible, because I'm reading out from the judgment, Chief Justice Mukherjee's judgment. How many judges in Ramjawai Kapoor, please?
5.
Thank you. So look at 12. It may not be possible to frame an exhaustive definition of what executive function means and implies. Ordinarily, the The executive power connotes the residue of governmental functions that remain after legislative and judicial functions are taken away. You'll come across this quotation in very many judgments. And then they clarify what can be the nature of the residue in paragraph 13. And paragraph 13, I'm reading the second subparagraph in paragraph 13. The executive function comprises both the determination of policy. I'm going to take each one of them up just one by one. Determination of policy as well as carrying it into execution. It also includes the initiation of legislation, 3. It also includes the maintenance of order, that's 4. The promotion of social and economic welfare, 5. The direction of foreign policy, 6. And in fact, the carrying on of supervision of the general administration of the state. At least 7 have been put, but this is not a finite list, we can add to it. The determination of policy. Do you want to have a policy that there should be private players in the coal sector or not? Just before the lockdown, you know that the government adopted that amended that 2015 Coal Areas Act. You remember when we were looking at it when we did West Bengal? That's a policy decision that you are not waiting only for nationalized companies. Coal India with its 4 subsidiaries, Bharat Coking Coal, etc. But you are also going to throw it open to national and international players. That's really what the policy that now is in place. That not only government, not only Indian, it can even be open to foreign prospects. That's a policy, a determination of policy. But this policy is going to affect rights of different entities. Therefore, they took the prudent measure of bringing it into law. But there are some policy measures that do not need to be brought into law. For example, take the new education policy. A decision that the medium of instruction could be not preferably in the mother tongue, but the choice is left to the government, to the parent, and to the child. That's what the new education policy says. It's not necessary that this become a part of a law, because there is no law in place telling us what the medium of instruction in schools should be. A couple of states have done it, but most of the states have not done it. It's done only by policy measures, that in this school, this language will be taught. Or a policy that it will be the policy of the government of India that we will try to build one school in every block. In every block, we will build a secondary school. Suppose the state government or the union has such a policy. Let me take state government because school education is usually done by the states. Now, this does not require a law. If we took a decision that within 1 kilometer of each other we will have a ration ka dukan, it doesn't need a law because the power to set up public distribution system is there in an entry. Okay, food and civil supplies is the entry. You can make a law about it, but you can also implement it by a policy measure. Now that determination of policy कि हर 1 किलोमीटर के बीच में हम एक राशन का दुकान लगाएंगे. You don't need a law for it. बस आप पैसा निकालिए. Civil Supplies Department will say हमें इसके लिए we need this much money. Appropriation Act में budget में Civil Supplies Department will पैसे आ जाएंगे and you will open your ration shop 1 kilometer के फासले में. You will have a ration shop. So that's a pure determination of policy, as well as carrying it into execution. You may have a policy, the war policy. Should we move troops into Ladakh or not? Should we move into all those new areas that we are all finding out about? Right? I've never heard of all these new names that I'm now hearing about. But we've heard about it now, all of us. Whether we will move troops there or move troops back, That's a policy measure. That is part of the executive power. It includes the initiation of legislation. So while lawmaking is made by Parliament, you can have a private member bill, but most of the bills that are moved in Parliament are governmental bills. And you know that one day in a week or something, I mean, this COVID times is very extraordinary, but usually that Friday afternoon used to be private member bill time, where a private member could move a bill. But otherwise, all the bills that are moved are by government. So the initiation of policy. So just for example, Cabinet decided that those 3 farmers' bills will be moved. Cabinet decided that those remaining 3 labor codes, Industrial Relation Code, Social Security Code, Occupational Safety and Health Code, will be moved last month. And last week it was moved and initiated into Lok Sabha, passed, and we know that yesterday it was cleared in Rajya Sabha. So the initiation of legislation. So please note, in our Westminster parliamentary model, executive power is initiation. Maintenance of order, police. How many police chowkis should we have? How many battalions of armed police should we have? But because under Article 53, Clause 2, armed forces of the Union are under legislative control. Whenever we want to raise a battalion, we have a law for the purpose. So the Army Act, Navy Act, the Central Police Act, we have legislation so that we know how many battalions, etc. So we have a Rashtriya Rifle Act, we have a SSB Act, then we have a ITBP Act, we have a CRPF Act, and so on and so forth. Okay, that's because these are armed forces, and that is done through legislation. But the decision whether we want to have one police chowki, one police post, these are all policy questions. So the promotion of social and economic welfare. So whether you want to have one hospital in a district, 10 primary health centers, 100 primary health centers, these would also be social welfare things which are completely within the domain of the executive. As we know, after the Ramjavaya Kapoor's case, in order to get money for building so many police chowkis or so many hospitals, you will need the legislative control of and the permission from the Appropriation Act. But you don't need to have a law which says there shall thereby be 300 PHCs in this district. You don't need a law for that. It can be done as a pure policy measure. Increasingly worldwide, we are moving from the realm of policy to the realm of rights-based legislation. Take, for example, the Right to Food Act that we now have. Earlier, going to a ration shop and getting the food grains was a benefit and it was part of the executive. But now by making it and transforming it as part of a right under a law, this is now a right which can be enforced. If you don't get food in a ration shop, you can file a petition under the provisions of the Right to Food and Food Security Act. You have made a rights-based legislation. And I think the most easy example that I can think of is the MNREGA. Before 2005, before the Mahatma Gandhi National Rural Employment Guarantee Act 2005, we used to have food for work programs. Jab famines hote the. The last big famine in India was in 1967, where there was a big drought and there were food for work programs. But these were pure executive programs. Government would decide kitne jagah, kahan food for work, hum, canal, nehar, khoj kar paise ya employment de sakte hain. It was a decision. Now, because they have chosen to make a law on it, it has become a rights-based thing. आप मांग कर सकते हैं कि you will have 100 days work per household, per job card in a area in a year. So what was earlier a pure discretionary executive policy has now become rights-based legislation. And you will see this transformation of policy to rights-based legislation as a general meta trend that you will see across different countries. But leaving that aside, I come back again. All these are instances of executives, but it's still not a closed group. It's open, it's inclusive, because anything can come into it. So what are the varieties of things that can come into it? Very quickly, if we look at it, okay, and I will
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा। कमेंट बॉक्स में अपना फीडबैक देना ना भूलें।